Here in person on this Quash warrant hearing, may I inquire as to whether he is attempting to appear via WebEx?
Let me ask. Anything, April?
No one by that name in the law.
Okay, thank you. Mr. Granger.
Your Honor, I was likely going to be opposing quashing the warrant anyway, so at this point, I'd say that he's failed to appear. We can strike today's hearing.
Granted, strike.
Not a good look for a Quash warrant hearing.
All right.
Thank you, Your Honor.
You're welcome. Anything else, Mr. Rogers?
Nothing further right now. I think the court admin was really on the ball yesterday, so we will have several to hand up.
Okay, thank you.
Thank you, Your Honor.
You bet. Ms. Kane, any matters ready to go?
I don't have any other matters, Your Honor, that I can call right now.
Mr. Johnson, I know you have a matter on this morning.
I have a couple, Your Honor. May I call number 18, Yenir Qualar?
Yes, you may. Well, first of all, good morning.
Good morning. This was set today for a review hearing. After Judge Peterson made some findings a few weeks ago, Mr. Qualar is getting a second evaluation per the order of the court. And I'm sorry, I don't know the exact date, but I know it's in October. So I would suggest maybe we set a review hearing October 8th for me to update counsel in the court as to if the evaluation's been done or if it still needs to be done.
Ms. Holbrook, what is your position on the matter? I'm just pulling the file up.
Mr. Johnson and I discussed October 15th yesterday,
Oh,
based on the fact that I would be away at training on the 8th.
I did forget that, Your Honor. That's fine.
Okay. How would you like the record to reflect that your client today?
Your Honor, we knew we were continuing, so I don't think there needs to be any
Any
FTA.
objections, Ms. Holbrook?
No, I did not expect him to be here yesterday, or after our emails yesterday.
October 15th?
Thank you, Your Honor.
Thank you, Your Honor.
All right. Let's see. Mr. Cuevas, do you want to do number 11? Greenmeyer? Well, first of all, good morning.
Good morning. This was on for a dose determination hearing, at least that's what it's noted up for. It was continued 2 weeks. Since I was unable to get in contact, I have no further record to make.
Good morning, Mr. Riley. You standing in for Ms. Chow? Or is this your cases?
This has just been assigned to me, Your Honor, at this point. We're going to ask this be continued 2 weeks one more time to make sure we have information from DOC on this.
And Mr. Riley, are you asking for a warrant today?
Yes, Your Honor.
Mr. Cuevas, do you have a position on the warrant?
Your Honor, I would ask that it just be a nominal amount of $100 to allow him to be present.
Court will note the FTA issued bench warrant. How much do you want, Mr. Riley?
$500, Your Honor.
Granted, $500 on each case. Mr. Cuevas, if you're ready, I'm ready. Go ahead.
That was everything, Your Honor.
Okay, thank you.
Thank you.
Ms. Kane?
I'll call one of them.
Great.
Yes.
How about number 12?
Yes, if we can call number 12, Danielle Donnelly. It's Ms. Wisman's too. Ms. Donnelly is out of custody, and she's present here to reset dates. So I would ask if we can reset it for a pretrial on November 19th.
1 second, Ms. Kane. There were 2 matters on. Which
Number
matter?
62, Your Honor.
Oh, I don't represent her on number 62, so I'm not sure what's happening with that. Mr. Rogers represents her.
Okay, thank you. On number 12, what are the dates you requested?
I would ask if we can reset pretrial for November 19th with trial December 8th.
Mr. Grandeur, any objection?
Your Honor, just covering for Ms. Wisman, who, along with me, is in trial right now, along with Ms. Kane, I don't see any reason to object to those dates.
Okay, thank you. Court will set those dates. Next court date is November 19th. Mr. Rogers, did you want to handle number 62?
Yes, Your Honor. If I could mirror those same dates, at defense request, I request a pretrial and omnibus of November 19.
Okay, Charles?
Trial date of December 8. And I need a
December
I'm sorry, December 8.
8th. Mr. Grandeur, any objections?
I do believe for that case, there will need to be a recognition that those dates would be outside of speedy trial as it currently stands. So if speedy trial is going to be agreed to restart today, we can accommodate
I
those
think he
dates.
said defense request.
If it's at defense request, I think that technically that's also fine, so we can do those dates at defense's request.
Granted, thank you.
Thank you, Your
You
Honor.
bet. Ms. Donnelly, November 19th, 8:30, both cases. Thank you.
Thank you.
Go ahead, Ms. Kane.
Yes, if we can call number 17, Joshua Manwaring. Your Honor, Mr. Manwaring is here for a treatment review.
1 second, let me get a prosecutor. That's Ms. Wisman's case.
Yes, I'm going to stand in while she's busy.
Okay, go ahead.
We were here for a treatment review, and I guess Mr. Manwaring wants to just address the court.
Okay, 1 second. Good morning, sir.
Good morning, Your Honor.
I have the file in front of me. Sir, you understand you have an attorney here representing you today. You understand that?
Yes, I
You
understand.
understand that this is a record and that anything you say can and may be used against you, the prosecutors here today?
Yes, Your Honor.
And based on that representation, did you still want to address the court?
I'm not sure exactly what that means. I was hoping we could just discuss today's hearing and, yeah, move forward.
Okay. Ms. Halbert?
I'm not sure what he has to say. My understanding is he is not in compliance with the treatment that was ordered by the court in March. Like, there's no documentation that's been provided,
As a
so.
psychiatrist, I have to find a therapy, but I can't fund it
Hold on,
right now
sir.
because
Hold
I
on,
don't have
sir.
employment.
Hold on, sir. Please don't interrupt the court, okay?
That was my fault, Your Honor. I asked him a question.
That's okay. All right. What are you asking for, Ms. Holbrook? I have read the judgment and sentence that was entered on March 12th. 1 second. Set forth. 1 second.
Sorry,
Okay, there we go.
It's my-
Thank you.
we're a little wobbly up here.
Oh,
Okay.
I'll lay up there, okay. Thank you. So it looks like the court entered a judgment and sentenced him to 364 days in jail, 362 suspended. And Ms. Hallberg, what is your position today?
Your Honor, I would ask that we reset this 1 week, and then the state can draft documents regarding the sanction that they're requesting, and if we're going to ask for him to be revoked or extend time.
Let's see. So you'd like to continue to October 1st?
Yes, Your Honor.
Any objections, Ms. King?
I guess not. No.
Sure, we'll see you on October 1st, okay? We'll see you then. Thank you.
Okay, thanks.
Ms. King, who's next for you?
I don't have any other further matters.
How about number 20, Perez, William Perez? I'm sorry, strike that.
All my other cases are in custody.
All right, thank you. Mr. Cuevas, are you prepared to go?
No, Your Honor.
All right. And I guess I'll go down the line. Number 2 on the docket is Guerrero, Mr. Hansen's case.
Your Honor, Scott Rogers standing in for Dennis Hansen today. I just minutes ago got notice of this and some instructions. May we set this one down, and I should be able.
1 second. Let me get the prosecutor on this matter. That's Ms. Clark's, excuse me, it's, Mr. Clark, are you going to handle this matter?
Yes, Your Honor. Which one is it?
Number 2, Guerrero.
Your Honor, I just got notes on these minutes ago. I am going to, if the court would be willing to set this down, I'm going to hand up a 3.4 waiver. And that's also going to be the case for number 3 and 6.
Mr. Clark, any objections to those?
No, Your Honor.
All right, I'll set that down. I don't see Mr. Stover in here. Thank you, Mr. Do you have any others, Mr. Rogers?
That's it for right now, Your Honor.
Okay.
Thank you.
All right, Mr. Stovern, there he is, number 7, Magana. Good morning.
Good morning, Your Honor. I was just calling
What
for
number?
Paula.
Go ahead.
I did receive a communication from her, but she does not appear to be here today, right now. So I would ask that we put this down so I can have a chance to get a hold of her.
1 second, I gotta find out who the prosecutor is here. That's Ms. Wisman's case.
No objection to send that down, Your Honor. It sounds like
All right.
it's return.
Mr. Holcomb's case on number 8, Greenmeyer.
When we issued the warrants on, Your Honor, there were 2 cases in that matter,
Yes,
number 8 and number 11.
correct. Thank you. Mr. Rogers, are you handling number 10 for Mr. Hansen?
Yes, I am, Your Honor. May I inquire as to whether Ms. Sanchez is attempting to appear via WebEx?
This is Ms. Wisman's case. Anybody standing in for the prosecution? April, do you have the money on there? Court will note the failed to appear. Ms. Holbrook, appears the defendant failed to appear.
And what number are we on your chart?
10.
10, sorry. Let me pull that up.
Defense has no representation to make, Your Honor.
And I believe they're out on $1,500 bail. Is that what the court shows?
Would you like me to look? I can do that.
Yes, if you can confirm that for me. I have that they posted that in July, but I just want to make sure.
This is not, I can't pass me up.
Ms. Holbrook, it looks like what I read is that the bond was denied on April 18, 2024.
Let me just quickly check the jail roster to verify that she's not there.
Court will indicate for the record on July 30th, 2025, signed a waiver setting forth pretrial today, trial on October 13th.
Based on her failure to appear, the state would ask for a $3,000 warrant, Your Honor.
Looks like 1,000 was forfeited back in 2023. So I'll note the failed to appear. Do you want a warrant?
I do for $3,000, Your Honor.
3,000?
Yes.
Court will note the FDA bench warrant, 3,000 cash or bond.
Thank you, Your Honor.
Thank you
Thank you, Your
for
Honor.
that. Mr. Johnson, go ahead.
Jump in, thank you.
Yeah, please.
It's number 60 on the docket. It's Ivan Jimenez, and he's present, Your Honor. This is on for omnibus.
1 second, 60.
60, that's correct.
Thank you. Let me find out who the prosecutor is.
It's Mr. Clark.
Okay. Okay. What are we doing today,
So,
Mr.
Your Honor,
Chairman?
we're satisfying omnibus. I can hand that forward.
Please.
Mr. Jimenez is, oh, you signed it over. Oh, I may have failed to have him. But, Your Honor, we're completing that today, but there was a pretrial violation allegation. Mr. Jimenez has a 24/7 alcohol monitoring device as a pretrial condition because of this charge. He's had that on since the end of June, and outside of one violation back on August has complied with it. However, there was a violation for a positive test for alcohol. At 5:15 a.m., he did provide a breath sample of an 03. We're admitting to that violation. And with agreement of the state, we're asking the court to impose an additional $2,000 in cash bail that he's to post within the next 7 days, and essentially a reprimand from the court. And I have communicated to Mr. Jimenez how seriously the court takes these violations and how seriously the state does. Luckily for Mr. Jimenez, he has complied with the terms of the pretrial conditions since this violation. He's had no criminal violations of the law before since this incident. So we asked the court to just grant that agreed motion to increase bail by $2,000 with a reprimand from the court.
Mr. Clark, I'm reviewing the conditions of release that was issued on June 23rd, 2025 with an amendment. Bail was argued at $5,000. The conditions indicate do not drive without ignition interlock device, do not consume any alcohol, enroll in smart mobile insight. The court did review the smart start contract. I'm prepared to hear the state's position on revoking or amending the conditions of release.
Yes, Your Honor. The state's in agreement to amend the condition of release to add an extra $2,000 bail to be posted within a week as a sanction for this positive test. It's, I think, also important for Mr. Jimenez to remember that if he does provide a positive sample, it's important to do the retest. It would not be the first time I've seen someone use mouthwash, get prompted for a test, blow a number, do the retest 5 minutes later and come back zeros because it was just mouth alcohol, not consumed alcohol overnight. But when they don't retest, we have to assume the worst.
Do you have an amended conditions of release?
Yes, Your Honor. What were we
Working on
doing
that?
for the next court date? Are we just keeping the October 15th date?
Yes, for now.
Okay.
Okay.
Thank you.
Mr. Jimenez, you understand that the court can revoke your conditions of release and place you in custody based on your fail to comply with my order. Do you understand that?
I understand.
You understand the order is not subjective. You have to follow it. At this time, the state has agreed to amend your conditions of release and add additional bail to your conditions of release as an amendment. You understand that?
Yeah, I do.
You understand that this is a discretionary ruling that the court does not have to follow.
Yeah.
You understand that?
Yeah, I do.
You understand the court could find you for failing to comply with that and remand you to the Benton County Jail until trial.
Yes, I do.
This, I know, Mr. Johnson. You understand that?
Yeah, I do.
And if you have another violations, the court may do that, remand you to jail, and it will be a no bail based on your violation.
Yeah, I do understand.
Your Honor, we had a very, very,
I'm giving him the talk, Mr. Johnson.
I do appreciate that. We had the talk as well. And this is, I do believe this is the first and last time you'll ever have to address this issue.
Okay. Make no mistakes, I will not hesitate to remand you to the jail pending trial.
Okay, most definitely. Thank you.
Okay. Based on the agreement of the parties, court will indicate bail will be increased by $2,000. And I want to remind you of the conditions. You have until 1 week from today to do that. That's October 1st to post bail. If you fail to post bail, the prosecutor will probably ask for a bench warrant, a no bail, to the extent the court will issue that if you do not post that bail. Once you post bail, you must maintain a current address here in the state of Washington. You also must maintain law-abiding behavior. No other criminal offenses. You must contact your attorney every Monday. Do not travel outside Benton and Franklin counties. You're also, pursuant to the addendum, and I want to be real clear, do not drive without ignition interlock device. You are not to consume any alcohol. You understand that?
Yeah, I do understand.
And you also are to have a smart mobile insight device on until further order of the court. Any further violations, I want to be real clear, and I've said this 3 times to you, you must follow all my terms and conditions of release, or I'll remand you to the Benton County Jail. You understand that?
Okay, yeah, I do understand.
Okay.
Thank you, Judge.
All right. Court will amend the conditions of release. So total bail is $7,000.
Thank you.
Should have been already taken care of.
Mr. Clark and Mr. Johnson, I just delineated what was originally set by Judge Ruff on Section 10 and articulate specifically in this order, and I'll have your client sign off on the order acknowledging
Great.
that order. Court will continue the matter to October 15th, 2025 at 8:30. Court is also in receipt of an omnibus application setting forth the following. Court will indicate that discovery is complete. Interviews to be determined. Nature of the defense is general denial. Mr. Johnson, or excuse me, Mr. Clark, any 3-5 hearing regarding statements. I just see statements referred to in the police discovery will be offered. Anything with the defendant?
Yeah, just reserving on
Yeah,
7
we're
and 3-5.
just going to reserve on that.
Would you like me to put reserve?
Please, thank you. I think that was an oversight, but we just received some additional discovery just within the last few days that I'll have to review, and we may have to have some independent testing. This is a blood draw case, so.
All right. Thank you, Mr. Johnson. Thank you, Mr. Clark. Total of 5 days, set at 7 for trial. Parties have signed off. I'll sign off on the omnibus application.
Thank you, sir.
You're welcome. Next court, I need your client to sign off on
Yes,
the
sir.
amended conditions.
Yes, sir.
April, can you help the court have him sign off? Thank you.
Thank you, Your Honor. Have a
You're
nice day.
welcome. Yeah, you too. Thanks. Good morning, Ms. Harkins.
Good morning. I have one very quick one, Your Honor. Number 30, Samantha Cook. Your Honor, she's on just for some compliance issues. She has to give reports showing that she's still in treatment, and she did so.
Okay, let me find out whose case this is.
It's mine, Your Honor,
Okay.
and for the record, I do find that she is in compliance.
Okay, you'd like me to strike the hearing?
I don't necessarily want it stricken since we're having it.
Okay,
I
in
just want the,
compliance.
thank you.
All right, in compliance.
Thank you.
Thanks, Ms. Harkins. Have a good day. Mr. Johnson, are you prepared?
May I call my arraignment, Your Honor?
Yes, please. One second.
Number 78, Clasen.
Please. 78.
Thank you.
Give me a second, Mr. Johnson.
Yes, Your Honor.
Okay. Good morning, counsel. I was looking, McNulty?
No, Your Honor. My name is Joseph Edwards,
Okay,
Deputy
well,
Prosecuting Attorney with Spokane County,
right,
covering this
well-
for Ms. McNulty.
Welcome to Benton County Superior Court.
Thank you, Your Honor.
And good morning. Mr. Johnson.
Your Honor, we are in receipt of a one-count information. Name and date of birth are correct. We will waive a formal reading and enter a plea of not guilty.
Court has reviewed the affidavit of probable cause. Do you find probable cause for the matter to proceed? Ms. Clasen, you were here on an arraignment. Mr. Johnson, I understand it's the first appearance, and I'm treating it as a first appearance based on the dismissal of the case prior, and I'm treating her just as a first appearance. Ms.
Understood.
Clasen, you have a right to an attorney. If you can't afford an attorney, one will be provided for you. You also have a right to remain silent before and during trial, and the right to refuse to testify against yourself. You also have a right to a speedy and public trial of an impartial jury here in Benton County. You also have a right to hear and question witnesses who may testify against you. You also have a right to have these witnesses appear and testify for you at no expense. You also have the right of the presumption of innocence to the charge is proven beyond a reasonable doubt, or you enter a guilty plea. You also have a right to appeal a termination of guilt after trial. In addition, if you're not a U.S. citizen, a plea of guilty may result in deportation or denial of naturalization. Do you understand all those rights?
I do.
Court winner, plea of not guilty, reserve the right to a jury trial. Counsel, conditions of release.
Your Honor, I sent proposed conditions to Mr. Johnson, and I provided a copy this morning, and I've signed it. I believe he and his client have signed it as well.
And this is an agreed conditions of release.
Yes, Your Honor.
Okay.
I have gone over those conditions with my client, Your Honor. We're aware of them and have signed off.
1 minute, let me review those.
Thank you.
Counsel for the state, I've read them. Are you, do you have a position on the alcohol monitoring device pursuant to RCW 4661-5022?
No, Your Honor, the state does not have a position on that.
And you are so for the record, you're just releasing her on her personal recognizance to maintain law-abiding behavior, remain in the state of Washington, not to consume or possess any non-prescription drugs or drug paraphernalia, not to operate a motor vehicle without a license and proof of insurance, obey all court orders, if under supervision or other conditions of supervision, maintain an address, it looks like have no contact with the witnesses, not to use or consume intoxicating liquor or use of marijuana or products contained with THC. There are no other conditions you'd like the court to consider.
Your Honor, at this time, that is the conditions the state has proffered. I will just add on to that with the geographic restrictions that the parties have agreed for her to be allowed to travel within the state of Washington or to Arizona, and Mr. Johnson is having his client sign a waiver of extradition.
You have no concerns if she has a passport or anything like that?
At this point, Your Honor, no. I do believe there is a passport. I know that there's mention in police reports of her having traveled out of the country. So at this point, the state is not agreeing to her traveling outside the country.
And you have no concerns with the community safety or anything like that?
Well, Your Honor, there are concerns with the community safety, and that's why the conditions that have been proposed are in there as far as not contacting witnesses or the victim's family, and also not consuming alcohol or any controlled substances.
Okay. Anything else, Mr. Johnson?
Your Honor, there's no mandatory requirement of any additional monitoring. I would also add, this case has been pending for 6 months, and my client has had no conditions during those 6 months and has faithfully followed basically what's in front of the court. So I don't think there's any concern that the court, understanding the court's inquiry, and it's well taken, I think that there's been demonstrated compliance with the fact that she's no threat to community safety.
Yeah, Mr. Johnson, I'm articulating a record, and obviously this is a record to the extent that that the parties need to, or the court needs to do to assure the court rules, case law is followed, and also to the extent that the court is well aware that any conditions of release are set forth a discretionary ruling to the extent that the abuse of that discretion may be criticized. Also, to the extent there's a court rule with respect to the court must follow. Also, the nature of the offense, specifically with conditions of release that the court must consider. While the court gives great deference to an agreement of the parties, the court has an ethical obligation and also a obligation to the community to set forth a basis on all cases that it sets conditions of release. Specifically, the conditions of release in such a particular trial or particular case like this. And the court is concerned to the extent that A1, that there's a community safety issue that the court wants to address. Two, all the factors under Criminal Court Rule 3.2 subsection B, and then the other issues that the court may be considered based on my review of the affidavit of probable cause. Therefore, the court is concerned to the extent that these conditions will be followed and that the community as a whole will be safe. The court will indicate for the record, I'm just making a record for both of you, indicating that a trial court affords discretion, is not free to act on at whim and in boundless fashion, and discretion does not allow the trial court to make any decisions inclined to make, and I'm quoting Curry at 191 when at 484 A trial court abuses its discretion if its decision is manifestly unreasonable or is based on untenable grounds or reasons. Further, a decision is manifestly unreasonable if it falls outside the range of acceptable choices given the facts and the applicable law and standards. It is based on untenable grounds if factual findings are not supported by the record and is based on untenable reasons based on an incorrect legal standard or facts do not meet the standards of do not meet the requirements of a correct standard. The court is specifically indicating to the record is that the purpose of bail is to protect the defendant from detention before a conviction. That further, bail is meant to secure the defendant's presence in court, but bail cannot be used to deprive the accused of a constitutional right to a speedy trial. Further, that a defendant does not have an absolute right to be released on personal recognizance prior to trial. If the court denied personal recognizance, the court must look to at least restrictive conditions that will reasonably assure that the accused will be present for further hearings. I'm quoting Criminal Court Rule 3.2, subsection B. The court also may consider other factors specifically as follows. The accused criminal, strike that, the accused history responding to legal proceedings, the accused employment status, the accused family ties and relationship to the community, the accused reputation and character, the length of the accused residence in the community, the accused prior criminal record, the willingness of a responsible member of the community to vouch for the accused, the nature of the charge, and other factors that the court may consider with respect to ties to the community. The court will indicate that there are additional conditions that the court should consider, specifically if there's if there exists a substantial danger that the accused will commit a violent crime or that the accused will seek to intimidate witnesses or otherwise unlawfully interfere with the administration of justice. The court may provide and order additional conditions. In this case, the court will indicate I've reviewed the affidavit of probable cause. The prosecutor sent a summons, not an arrest warrant. The defendant appeared with counsel today. Based on that summons, the court will find that the defendant does not have any any criminal history, has not had any other orders other than the preliminary hearing that were set forth. The court will find that while the court was concerned to the substantial danger to the community, basing all the factors and balancing those, the court will agree to the extent of the conditions of release and set forth them as follows. I'm releasing you on your personal recognizance to maintain a current address here in the state of Washington. You also must appear to all court dates. You must have regular contact with your attorney. You must remain in the state of Washington or Arizona. If you do travel outside the state of Washington, I'm sure that you must, or strike that, I'm ordering that you sign a waiver of extradition if you do travel outside, and that will be filed with the court. You are not to commit any new violations. You are not to consume or possess any non-prescription controlled substance or any other drugs unless you have a prescription and you notify the prosecutor. You're not to operate a motor vehicle without a valid license or proof of insurance. You must obey all court orders that are in effect at this time. You're also ordered to not have any contact with any of the state's witnesses that have been identified by the state. You are not to use or possess any alcohol or intoxicating liquor. You are also not to consume or possess any marijuana or any product that contains THC. Do you understand that?
I do, Your Honor.
I will sign the conditions of release. Based on the out of custody, do you want to set some court dates based on a 90-day schedule?
Your Honor, we're going to ask that omnibus be set for October 22nd.
Okay.
Pre-trial November 12th.
Okay.
And trial December 15th.
Is that acceptable to the state?
Yes, Your Honor.
And anything else?
Your Honor, I will hand forward that advisement of rights with the dates. I do have the signed waiver of extradition. Additionally, we have an agreed motion. Since the case was unfiled, the defense has not had access to either the vehicles involved in this case or the blood. And so the order addresses the transfer of the blood to our independent lab for analysis. And again, that's an agreed order. The issue with the vehicles we're working through, so I don't think an order will be necessary for that.
Do you have a position on the request in this order?
Your Honor, Ms. McNulty in my office prepared that order in connection with Mr. Johnson. So the state is in agreement for the B vial to be sent out to the independent lab. And as Mr. Johnson indicated, we have been in contact with the Richland Police Department to set up a time for viewing of the vehicles involved.
It's in Richland, not out here?
Correct, Your Honor. It was Richland Police Department, so.
And do you have any issues with chain of custody or?
Your Honor, I believe it's addressed in the, it's the B vial, and I believe it's addressed in the order as well for chain of custody to be provided by the State Patrol Toxicology Lab.
And you're agreeing to the order?
Yes, Your Honor.
Okay. Mr. Johnson, I'll sign your order authorizing an independent lab analysis of the blood evidence as set forth in the order. Court is in receipt of the acknowledgement of rights. Court is in receipt of the waiver of extradition. I've signed your order.
Thank you, Your Honor.
Anything else?
No, Your Honor.
Anything else?
Not from the state, Your Honor.
Thank you.
Thank you, Your Honor.
Mr. Holt, would you like to call your case?
Sure, Your Honor, number 16, Jose Valencia.
Okay, thank you. Let me get to the case real quick. Good morning, Mr. Holt.
Morning, Your Honor.
Morning. This is Ms. Holbrook's case?
It is, Your Honor.
Okay.
Your Honor,
And
we're
what are
kind
we
of in a
doing today?
unique situation here. We entered a plea and pled guilty to gross misdemeanors. He was sentenced on gross misdemeanors, and he was sentenced, basically, the judge said that she was reserving 60 days out of the sentence because he had actually served